The landmark decision in the Quebec Superior Court case R.V. White and Montour was handed down by the Honorable Judge Sophie Bourque earlier this month. The decision saw a permanent stay of the indictable offenses against both Kahnawa'kehró and a dramatic turn in the legal landscape of Canadian Aboriginal law. The potential for change in how courts address issues surrounding Aboriginal rights under Section 35(1) of the Canadian Constitution Act. KTV captured the perspectives of the political and legal representatives of the MCK, Ratitsénhaienhs Kahsennenhawe Sky-Deer, Chief Political Advisor Winona Polson Lahache, and Director of Legal Services Mary Lee Armstrong.
Well, I think it was definitely historic. I was there in the court, and as she was reading, obviously it was like an executive summary of the 450-page report. As some of the sections she was reading, I was floored, like literally moved that she literally took that much time to understand what the relationship means for us as it pertains to, I guess at the time, Britain or the Crown, and that we looked at this relationship as something being real and genuine, and that, you know, it was something that we would utilize for generations to come, right? It was one that was on not only defense and military, but, you know, for our economy, and that, you know, we were like brethren. So, you know, it just goes to show that Canada hasn't necessarily stuck to their end of the deal.
For the first time, they really ended up listening to all of the oral evidence that was presented and provided it with the proper deference. There was a law that she said that rejected the doctrine of discovery and the terra nullius, which was really important, and included a law about the historical relationship. So it ended up being called a metanarrative. So all of our historical relationships with the British were used, and they looked at the Silver Covenant chain. They looked at this relationship, which was the basis, and found that this relationship still existed.
Normally, courts will only go back to a certain point in time, and in this decision, they went a lot further back, and they had basically recognized that treaties that were established at point of contact or a lot closer to point of contact were actually considered legitimate treaties according to the court. And so this is something that was a very big step forward in terms of the Canadian framework and the way that they look at Aboriginal rights in the country.
Finally, somebody gets it, and somebody is, you know, rendering a decision that is in our favor and can open the opportunities for us to assert rights, to be able to exercise, you know, who we are.
The decision that was rendered has tremendous impact for the way that Aboriginal rights will be looked at, I think, in future, depending on what happens during the appeals processes. If the decision isn't too heavily narrowed during the appeals process, it will actually widen the way that we look at what the tests are in order to prove an Aboriginal right. In a functional context, this could mean the difference between being able to actively negotiate a matter instead of being told that you don't actually have the right to be able to even sit at a table to negotiate.
So the Van der Peet test, what it did was it effectively froze our rights in time. Any Aboriginal right that needed to be proven, first of all, had to be shown to be integral to that nation, and it had to be shown to have been practiced at the time of contact. So you're effectively having to freeze those rights in time, and it made no sense. It made no sense in this modern context. But because of how law works and stare decisis, so meaning that all the decisions that have come before are what you have to follow, this is the first time we've seen anything where they're re-examining those tests. So this is a lower court judgment. So I can't say it's effectively changing it immediately, but that hope is there. That hope is there that they're going to re-establish a new test. And she has addressed that as well. She actually set out a new test in the decision, an example of what should be followed.
One of the things that occurred in this decision was the recognition of the Haudenosaunee, and done so in a very early context and recognizing those interests on a nation level. Normally in Aboriginal rights, the tests that you have to go through, there's a lot of work in figuring out whether or not you're the rightful group that should be exercising those rights, whether it's to assert them or to protect them. And some of the changes that are being proposed by Judge Bourque in the decision are to change those tests, to put less weight on the individuals to have to test and more looking at it from a nation context. So that could potentially really change the way that we look at things moving forward.
So this is a really good indication that it's time. It's time that Aboriginal rights is looked at in a new lens, in a new fashion. I think part of the problem is the fact that it's still going to have to go through all of these other courts in order to get to the Supreme Court and to really be reviewed again. So I don't think things are going to be changing overnight in Aboriginal rights, but it's giving us this glimmer of hope, and it's something that we've been striving for how long. It's really amazing. I didn't think I'd actually see this in my lifetime, that they've actually changed these tests and are looking at addressing these awful decisions actually that were made.
It definitely allows us to modernize and be able to say, well, this is what is there for us now, whether it's gaming or it's tobacco. We have a right to an economy. We have a right for our people to be able to flourish and succeed and to take care of ourselves for ourselves. And I definitely think it just doesn't leave us stagnant now, and that our rights are constant and are evolving, and that they can't hold us to standards that are obsolete and historic.
The MCK, at the time the case was going through the court system, had made a decision not to be involved in the case. To really boil it down and make it plain and simple to understand, the MCK had essentially decided that one of the largest factors was because the MCK viewed it as a nation issue.
What they were arguing, in terms of a defense, we felt it wasn't our place. That covenant chain relationship, where that originates from, isn't from this colonial government, and I know that there's an evolution and there's things happening, right? We've kind of taken Mohawk Council of Kahnawake and made it communal governance, but in the eyes of Canada and other institutions, it's still a governing body kind of born out of the Indian Act. So it wouldn't make sense for us to go and argue these concepts that were put forth from Mohawk Nation Council of Chiefs or from Haudenosaunee perspective, because that's not what this government is. So it kind of would have been hypocritical, and it even could have been more damaging. So I think we made the right decision in standing back and obviously supporting Hunter and Derek throughout the process and saying, we're going to be there, but in terms of being involved through this governing body, it just wasn't the right fit. And in retrospect, I'm glad we made that decision to not get involved, because it might have went in a whole different direction.
I think we can all say without any doubt that the decision will end up getting appealed, probably all the way to the Supreme Court of Canada. The manner in which the decision has been drafted and some of the changes that it's proposing to the way that Aboriginal rights are considered in the Canadian context today is so drastic. I cannot imagine that even in an age of reconciliation and all of this sort of language that's being put out by the Canadian government, that it would allow that to stand without challenging at least portions of it or attempting to at least narrow it.
The first level of appeal will go to the Quebec Court of Appeal. So within early December, we'll be getting something, I'm sure, for them appealing that, because they're not going to want this decision to stand. It is a lower court decision, so obviously it's not as if it's those tests no longer exist, but they're going to want to address some of the things that the judge put in there.
I know that's what they have to do to save face and to try to maybe close the window of what this decision has done now in terms of, rights assertion and all that. So par for the course, if they do, but I definitely think it's already now set a stage and has shifted the way that we can go into different discussions and negotiations with government.
It's probably going to take about 3 years just to get to Court of Appeal. After that, in all likelihood, it'll go to Supreme Court. And that could be up to 6-7 years from now. So we still have a long road ahead.
I would be very surprised if it didn't go all the way to the Supreme Court. And so I think that one of the important things at this point is for the Haudenosaunee to figure out what their involvement is going to be in that process going forward. How will they work collaboratively to ensure that the decision is not too narrowed and can become a useful tool moving forward?
This is a great decision. This is something that's positive for us, but at the same time, it doesn't mean that people are not going to get arrested. It doesn't mean that they're not going to be charged and that things are just going to overnight change. Yes, that is what we want to happen, but it doesn't mean that's effectively going to happen overnight. So there's still a long road ahead because, as we said, it is a lower court judgment. So superior courts will be looking at this, but the other courts and higher courts aren't going to be bound by this. Not until it goes to the Supreme Court of Canada and they have their say on it. Really, at this point, it's a little bit difficult to say what's going to happen. But I also don't want to be all doom and gloom. We understand that it still is a judgment. It's a well-written judgment with a very respected judge. So I do think it's positive in that, but it doesn't mean things are going to change overnight.
There's a larger nation-to-nation relationship that has to be developed between the community and the nation rather, and Canada. That extends beyond an elected council's authority. It's a nation issue. So I think that at this point in time, as a community, we really have to put some thought into figuring out how there's a collective approach to ensuring that everything is moving towards that goal of facilitating that there's actually real nation-to-nation dialogue occurring between the Haudenosaunee and Canada, and that everyone has a role to play in ensuring that actually takes place in a good way.
Already at Kahnawake-Canada Relations, Quebec Kahnawake Relations tables, we could utilize this decision to say, see, we've already been asserting these kind of things and pushing for the advancement of recognition of our rights, and that our relationship is different. And you have to come at us as equals in this relationship, and that you have a duty to consult. And a lot of the legislative things that are impacting on our communities are still coming from this place of them feeling that, they have superiority, or that they're going to dictate to us how to govern our affairs. So it definitely levels that playing field, and it gives us more leverage to argue things from a rights-based perspective, and it definitely already changes the landscape of us being able to utilize it, whether it gets challenged or not. I think it's just exciting times we're in, and we're gonna keep pushing, and the momentum is on our side.